I'm Ben Meiselas from the MeidasTouch Network. A district court judge in Alabama just made a very important ruling this week that will likely add at least one additional congressional district for the Democrats in the state of Alabama after the United States Supreme Court, in a case called Allen v. Milligan earlier this month, ruled that the district court's decision should be affirmed, whereby the district court decision had previously held some time ago that the newly gerrymandered maps in Alabama creating only one black congressional district was a racist map, given the population of African Americans living in Alabama. I want to go over this district court decision right now, though. So what happened was the Supreme Court reached its holding earlier this month, and then the Alabama district court judge just made this ruling ordering the state of Alabama by July 21st to present its own map consistent with the United States Supreme Court decision affirming the district court's prior ruling that the map that was used for the 2022 midterms was indeed a racist map, was indeed an unlawful map, that Section 2 of the Voting Rights Act of 1965 should not be overturned, that the district court judge used the proper standards under Section 2 of the Voting Rights Act and previously declaring the prior Alabama gerrymandered map that was actually used as a racist and unlawful map. And here, if you look at paragraph 4 from the court's order, the court will not instruct either a special master or a cartographer to conduct any work until July 21, 2023. So if the state does not create the map consistent with the district court's prior rulings, the district court is going to appoint someone to force them to do it consistent with the United States Supreme Court ruling. So let me just remind you what went down here. And I think the Democracy Docket run by Mark Elias does a good job explaining it. This was a lawsuit that went before the United States Supreme Court regarding Alabama's congressional map drawn with the 2020 census data. There were two lawsuits that were originally filed on behalf of voters and nonprofit organizations who alleged that Alabama's congressional maps dilutes the voting strength of black Alabamians in violation of Section 2 of the VRA, the Voting Rights Act, after a district court blocked the map. So the district court blocked the map and ordered the creation of a new map with two majority black districts. The Supreme Court then stepped in and paused this order, ensuring that the state's previously blocked map, its racist and unlawful map, which only contained one majority black district, was in place for the 2022 elections. Thereby, Alabama Republicans picked up a seat that they otherwise shouldn't have. And because this stayed, similar proceedings in North Carolina and other proceedings that were waiting on the Supreme Court ruling, this could actually result in about 5 seats now going to the Democratic column as a result. But because the Supreme Court did what it did originally by blocking the district court's order before the 2022 midterms, that's actually, those 5 seats are the difference of control in the House of Representatives. But now all these other states are going to have to change their maps consistent with this new ruling, what the maps should have been in the first place. So the one thing I want to address, though, right there is that this case was brought by civil rights groups, and it was brought by other individuals to challenge this map. Now, in the past, before a decision called Shelby County versus Holder, again, that's another case involving Alabama, but it's the Shelby v. Holder decision from 2013. Before that, there was what was called a pre-clearance requirement in the Voting Rights Act of 1965, found in Section 5 of the Voting Rights Act. And preclearance meant either the Department of Justice or a 3-court district judge panel would get these maps first, and in the first instance, they would make the determinations that the map was satisfying the conditions of the Voting Rights Act, and specifically satisfying Section 2 of the Voting Rights Act, which is found at 42 U.S.C. Section 1973, which states no voting qualification or prerequisite to voting or standard, practice, or procedure shall be imposed or applied to any state or political subdivision in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color, or in contravention of the guarantees set forth in Section 1973B, and this was incorporating the language from the 15th Amendment of the United States Constitution. And so in Shelby County, it found that the formula to determine the pre-clearance requirements, that the formula was unconstitutional. So since the Section 4 formula was declared unconstitutional, you couldn't apply a formula to pre-clearance because the formula doesn't work, so it knocked out the pre-clearance requirement. So whereas before the burden was on the state legislatures to have to submit a map that was consistent with the Voting Rights Act to a 3-judge district court panel or to the Department of Justice to approve it, that it was not a racist map, the burden then shifted. So the legislatures, after the 2020 census, with the Shelby decision coming into play in 2013 when they were doing these maps, the legislatures were now free, without any oversight of district court judges or the Department of Justice, to pass whatever racist maps they wanted to. And then what happened is you had to wait for a challenge to be brought by a civil rights group or a nonprofit group or an aggrieved state legislator or someone like that to affirmatively sue. Lawsuits take time. And what the states would do is they would submit their gerrymandered maps right before the midterm elections. So, or as soon as they were able to submit them, the last possible date before a midterm election. So this way, when a district court judge may strike it down after a lawsuit is brought, and that's what happened in this specific case in Alabama, then the Supreme Court would come in and rule, well, we previously have created a precedent called the Purcell precedent, which is, as we get closer to an election, courts should not disturb the maps of state legislatures. We should wait until after an election. So combining the removal of pre-clearance from Shelby versus Holder, combine that with the Purcell principle, what that results in is these racist maps were allowed to stand for the 2020 midterms, and they were only allowed to basically be challenged afterwards. In the meantime, the Republicans were able to get in a lot of members of Congress who otherwise shouldn't have got in because the map was unlawful. And now, after the fact, we're seeing the remedial measures that are being done in remedial orders because the Supreme Court has finally ruled. Now, what the state of Alabama and other Republican-led states have been arguing is that Section 2 of the Voting Rights Act itself should be unconstitutional. And they say it's unconstitutional. You should knock out Section 2 of the Voting Rights Act because it's not race neutral, while ignoring the fact that the 15th Amendment and the Voting Rights Act of 1965, its very nature is trying to address the racism that has led to situations where you can have a significant sized population of African Americans in Alabama, but only representation in one congressional district. And so that is how Republicans tried to just completely obliterate the Voting Rights Act totally. And ultimately, they did not succeed in the Allen versus Milligan case. They lost that case. Section 2 was a 5-4 decision. Justice John Roberts wrote the decision for the majority. So it was a very close decision, but Section 2 has survived. And as a result, with Section 2 surviving, now we see these remedial orders, like the one I just read, where the states have to now, that have put forward these racist maps, we're going to see this in North Carolina too and some other states, they now have to put forward maps consistent with the Voting Rights Act that's existed since 1965. And so here we have Judge Anna M. Monasco, U.S. District Court judge in Alabama, making this order, compelling the state to do that. So just wanted to give you why this order is so important by the district court judge. It's going to lead to another Democratic seat. And the federal judge here, Monasco, she's not taking any chances because she's like, all right, if you don't make that change by the 21st of July, I'm making it for you, but we'll give you the opportunity to do this. So that should add at least one congressional district. We'll talk about that when that happens, but it's important to be focused on these critical cases and understand their origins so we can understand generally what the plan is from some of these MAGA Republicans, all of them, who are trying to kind of undermine voting representation through racist gerrymandering and the steps being taken to create an even and fair playing field. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 1.5 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch and wherever you get audio podcasts. Subscribe to the MeidasTouch podcast and have an excellent day.
Love this video? Then you'll love the MeidasTouch podcast. Listen as my brothers and I break down the latest news and chat with top political leaders on the fastest growing pro-democracy podcast in the world. New episodes drop every Tuesday and Friday. Add the MeidasTouch podcast right now wherever you listen to your podcasts.